One lady had said that one of the MP's daughter, if she was raped, then what would have happened? This is something else. And what would be the compensation? One lady named Krishna had uttered this.
The reason you have registered a case and picked up the petitioner is unacceptable.
Well, that is not under challenge.
No, that the submission has been recorded.
Yes.
Have challenged that also in the writ petition.
Krishna Maji was the initial made a
Right.
remark,
Right.
and the petitioners are implicated as having instigated the principal. Is it a ground for arrest?
Yes.
Is it a ground for arrest?
But is it a ground?
What is the matter about?
But I'll tell you, Lakshmi, what has happened, Millard. Two ladies, Millard, were arrested in connection with a case. The petitioner number 2 was first arrested. Then she was produced before the magistrate. The magistrate says that since POXO is involved, I cannot pass any order. Sent to judicial custody and directed to be produced on the next day. On the next day, that is on the 9th, this has happened on 7th is the arrest of the second petitioner, the petitioner. 8th, she was produced before the magistrate. Magistrate says that produce her before the POXO court on 9th. And she was sent to judicial custody. On 9th, Millard, the petitioner number 1 was arrested.
No, this is relating to this RG car matter.
Some way connected, but Millard, it is not directly, Millard, with
No,
the...
this is the matter where
agitation is a Navanno Obija.
No, this is not Navanno. This is not Navanno.
To RG court.
No.
Which is of course politicians.
Well, here, Millard, one lady had said that one of the MP's daughter, if she was raped, then what would have happened? This is something else. And what would be the compensation? One lady named Krishna had uttered this, and where the allegations are that the writ petitioners over here had supported her and they had clapped, etc. Now, this is the subject matter. This has got nothing to do with no one. No. Now, here, Millard, what happened is, Millard, the allegation is that the writ petitioner number 2 was tortured in custody. That is the allegation. Now, Millard, I had demonstrated before the learned court, single judge, that they were represented before the learned court below at the time of grant of bail or consideration of bail prayer on 6 to 7 occasions. There were no allegations of custodial torture. Even on the day on which, Millard, that is 5th of October, when they were granted bail, there were no allegations of custodial torture. In between, on 17th of September, Millard, the instant writ petition was filed, obviously affirmed by some other person, saying, making only one averment, saying in one paragraph that in the court when they were produced, these writ petitioners were produced, they wanted to ventilate before the judge that they have been tortured in custody, but they were not allowed to.
Why were they picked up?
Millard, they were picked up, I think, from their house. Okay?
Why were they? What was the case registered against them?
Millard, the case was, Millard, under the POXO, and they were, Millard, abettors to that. These two petitions were.
Millard, somebody.
Wait. Please. Now, Millard, I had demonstrated before the learned single judge by placing reliance on 7 to 8 orders where, Millard, there were no allegations of custodial torture, though they were represented by learned advocate. Then, Millard, my second point is that, Millard, every time or, Millard, during the police custody period, Millard, when, Millard, there were police custody for only 3 days. Millard, there were...
The learned single bench has recorded that upon reviewing the medical report,
para 20,
it reveals that Miss Ramadas was subjected to physical torture.
In police custody.
No.
Yes. Now, Millard, what is being reviewed?
No. What is the allegation in the FIR?
Millard, if I have to put the annex, page 50.
So, para 11, the learned judge says,
Yes, Millard.
The principal offender in this case, one Krishna Maji, who made the initial remarks about the minor, has already been arrested and is currently in jail custody. The petitioners are implicated as having instigated the principal offender's action and are therefore culpable in the alleged offence.
Right.
The fact that the principal offender is in custody strengthens the prosecution case against the petitioner.
Right.
That's the submission made on behalf of the state by the learned advocate general.
Yes. Your Lordships were referring to paragraph 20 of the order under appeal. Milord, please have a relook to paragraph 20. Where the conclusion drawn, Milord, in my very respectful submission cannot be sustained. Why?
No, this medical report is by the
Correctional home.
superintendent of the.
Therefore, she was not in police custody?
No. After she was produced,
Yes.
Judicial custody was ordered.
Yes.
Probably she has been taken to the correctional home. In that, an initial examination takes place.
Yes.
And
No
the
injury.
record.
No injury.
And you cannot be arguing against your own record.
Right.
And
Right.
which says that there was physical torture. So between 7th to 9th or 7th or 8th till she was remanded, she was in the custody of the police. Unless you say it was self-inflicted injury.
I'll tell you, Lordship, Milord.
And the reason why they were picked up and roped into this case,
But that
this is very, very, in my personal opinions, was very shameful. When the court was closed for vacation, and knowing fully well that there was no vacation bench sitting, some 15 or 18 doctors were picked up. Why do you precipitate this issue? And therefore, they had to approach me. Then I had to make a request to honorable judges who are available in station. And this is all surreptitious manners. And everything relatable to the incident, certain things which is not to your flavor, immediately you spring up with action. Something is not palatable to you, you just keep the file closed. And how you instigate, how these people instigated them. And that person, the principal offender, that Maji is still in custody.
No, I think she has been granted bail. Charge sheet has also been filed. Yes. Now, Milord, I have got a few points, Milord, for your Lordship's consideration.
No stay, sir. We won't extend this.
Milord, kindly consider this, Milord. When Milord, item number 1 was being taken up, Milord, your Lordships had referred to the Supreme Court decision, which went from our court that.
But here the learned judge has recorded certain reasons.
No, we were not addressing the court on the CBI investigation. I did not utter a single word on that.
It is not a case where.
Yes. And on the first day, CBI investigation.
We did that. We did that. Supreme Court did that. In RG car, we did it.
Milord, I have a right.
Yes. And Supreme Court did not interfere with the order. The writ petitioners are still before us.
Milord,
probably now the matter is being heard by the Honorable Supreme Court.
Milord, heard for 5 days.
No, it can be heard for 5 days. That is not very important. What is important is my learned friend conceding.
The Advocate General appearing in Birla Lodha matter, 7 days we heard him.
Yes.
7 days we heard him. 1 year and 1 month. Continuous hearing, courtroom number 16. 14 honorable judges couldn't hear the matter because all of them had appeared.
My lords, by Milord, referring to Milord, this order of the Supreme Court, we don't have Milord physical copies. Kindly have a look to this.
Sir, one more thing.
Yes.
Now the allegations against the state police.
Yes.
And now the state has come forward with the stand.
Yes.
The concerned police has not come forward with any individual prayer saying that, sir, the allegation made against me is false. I was not in station. I was not in duty. I was posted in that para. I was not here, etc. He has not come. So the state need not see if suppose a public servant has committed a mistake. And it is according to, and the state, if it's a responsibility of the state to find out whether he acted within the 4 parameters or within the 4 corners of law.
Yes.
If it is beyond that, you can't be supporting it.
But may I say this, Milord?
And yesterday, I read in the newspaper where the Honorable Division Bench has made an observation that a police personnel who's married cannot cohabit with another lady.
Yes, I found that in the newspaper also.
Today in the newspaper,
yes,
we have read.
I found it in the newspaper also. Now, Milord, so far as Milord, the individual police officer is concerned, Milord, the directions for affidavits are being given, Milord, after Milord directing CBI to register a case.
If your officer is so confident You just hand over the file to CPI and say, please investigate, find out.
My lord, we have,
And it will take another 8 months for them to even open the file.
but may I say this, my lord? My lord, we have also, my lord, set up, my lord, an ACT to look into the matter. Therefore, my lord, assuming, my lord, the allegations are to be correct.
Prima facie, the reason you have registered a case and picked up the petitioner is unacceptable.
But that is not under challenge.
No, that the
yes,
submission has been recorded.
Yes.
Have
Saying
challenged
that
that also in the writ petition.
Krishna Maji was the initial made a
Right.
remark,
Right, right.
and the petitioners are implicated as having instigated the principal. Is it a ground for arrest?
Yes, yes.
Is it a ground for arrest?